Thank you. Good afternoon to all of you. I'm very grateful to Didier Fassin for his invitation to share your views, your opinions, your debates. And I'm grateful particularly because, as everybody noticed, I'm not of the academic side, you know, of the administrative side. I'm proud to sit beside the three eminent professors who came across the Atlantic Ocean for us, and they explain the case of United States. If you allow me to make one comment about what I heard this morning, is this one. We have a problem with the public opinion, anyway, in this country, because it's convinced that there is a unique and direct link between the number of crimes and the number of detainees in a country. And we all know that it is not true, that many other causes interfere. For instance, the organization of justice, the use of pretrial detention, the use of conditional releases, and all sorts of factors which determine, in fact, the number of detainees in a country. And of course also the terms of the penal law in this country. The law is changing every year in the penal field. So that was the remark I'd like to make. Mrs. Resnik, please, would you come here? I feel sorry because of the distance between us. It made me think of the distance between Vladimir Putin and Emmanuel Macron in Moscow some time ago. But I'm very glad to welcome you here. And you are professor of law in Yale University, and we all know what Yale University is, and we'll hear you with great interest.
Thank you. Good afternoon. I'm glad to be here. I'm going to talk more about a story of origins. Prison isn't a ready-made, Marcel Duchamp. We didn't take it off the shelf. And so I want to give you glimpses of about 250 years to explain where we came from as well as where we are and how the world we currently inhabit is made. And so I'm going to start, assuming, let me see if this works. Voila. Okay. More than 250 years ago, actually, this is from a French edition of 1766, a man named Cesare Beccaria, or depending on which language you pronounce it in, wrote a book. He was a marquis. He wrote it initially anonymously because he was afraid he'd be prosecuted. It's called On Crime and Punishment, On Crimes and Punishment. He was a pioneer, meriting our attention, because you can see this is a frontispiece, the iconic image of justice, seen as rejecting three severed heads. Beccaria is famous today, in part because he's one of the first people to oppose the death penalty and write about the importance of governments needing to justify the forms of punishment they impose. So with a mixture of natural law, social contract theory, and utilitarianism, he argued that governments were supposed to improve social welfare, and to do so, the greatest possible happiness or the least possible unhappiness, it was better to prevent crimes than to punish them. His complex, not completely consistent account is sometimes summarized. I've tried to do slides in French and English. I'll stay in the English. The severity just exceeds the benefit the offender receives. Any additional punishment is superfluous and therefore tyrannical. And it had to be public, prompt, necessary, the least possible, proportionate, dictated by law. There's lots more to say. I'm not going to say it here and now. But what I want to underscore is both that he's at the front end in the cross-Atlantic exchange around purposes of punishment, and he also at the time, while he's rejecting the very common punishment of killing people, capital punishment, he's endorsing as alternatives things that are proportionate, the least possible, include stomach-churning examples of not of execution, but of iron cage, fetters, chains, rod, yoke, which, as compared to execution, sounded mild under the circumstances, which is an important point about all conversations about punishment and much else, is we start from baselines. What we take to be the normal predicate is what we compare to. And so Beccaria is one of several Enlightenment theorists, Jeremy Bentham, famous in England, who wrote about everything, including punishment, John Howard, another who inspected obsessively as an early sociologist and saw filth and measured spaces. And these white European men merit our attention today because as social scientists, entrepreneurial public intellectuals, lobbyists, and activists, they put punishment on the map of political theory, and they helped yoke the power of the state to an idea that it needed to justify the punishment it imposed. Through theirs and other efforts, the pure and often random violence and terror of monarchical regimes was losing its legitimacy as they insisted on justification. They talked about having good reasons to differentiate among criminal acts, and some forms of punishment needed to be abolished. In your terms, they were reimagining punishment, and what they did is each of them had their own punishment that was their bête noire. Beccaria, as I said, wanted to end capital punishment. Bentham railed against transportation to the colonies, and others had other efforts at trying to alter the punishment scene they inherited, and all of them promoted the alternatives. So they added punishments as well as tried to delegitimate others, and incarceration was what many of them championed. So here, following in the footsteps of the Netherlands, where in the 1780s, actually Europe and England had houses of detention, as did the United States, for a long time. And Amsterdam had a whole different, many of them. This is the Men's House of Correction, built in the 1780s as one of the largest buildings in the city at the time to hold 700 people, utterly oversized for its environment, as a great exemplar of social control. It comes from, the print I have, comes from a very famous, once famous, 1783 atlas of more than 100 prints that were put together to advertise the virtues of the city of Amsterdam, which was seeking to invite commerce and tourism through images of its ports, bridges, canals, churches, 2 synagogues, a town hall, markets, and many homes for the elderly, the orphans. In fact, a fifth of all the prints of the 100 prints were of houses of detention of different kinds, because the aim was to curb, state-of-the-art, vagrancy and crime through detention of people labeled deviant, fighting poverty with a building, which actually fits what we heard some this morning. And as bizarre as it may seem for us now, amidst those 100 prints is this scene here of the interior courtyard of the Men's House of Correction, where a misbehaving prisoner is shown flogged while spectators, guards, and other detainees watch. So this is not idiosyncratic iconography or imagery. European artists depicted, some glorified, various examples of corporal punishments. And whipping was not in any way unique to the town of Amsterdam. I'm going to cross the Atlantic briefly. This is the Newgate prison in Connecticut, where I live, from 1799. Another image of a man being whipped with lots around. So degradation was known, shown approvingly, and it was theorized. But on occasion, the misery of the prisoner took center stage. And for here I'll go, This is an English print of a French prison, the Bastille, in which this saintly figure is shown imprisoned by the French in this captive with a glowing light chained to the leg. And here we see an example between these first few images of the way to glimpse the 18th century praise for, concern about, and the expanding physical presence of prisons. This new imagined punishment was a remarkable success in that incarceration did replace in many places stocks, branding, and execution, and became an icon of criminal law enforcement. As this picture also reflects, with the birth of incarceration came concerns for the miseries that it imposed, and in some places, some people were appalled, and the goal was to improve prison systems. And here in Paris, Charles Lucas wrote 3 volumes he called The Penitentiary Science. Like the Italian Beccaria, he called for the end of capital punishment. Like the Englishman Jeremy Bentham, he preferred prisons as what he called a replacement penalty. And 2 famous Frenchmen, Gustave de Beaumont and Alexis de Tocqueville, came to the United States in the 1830s in search of models. And here's a drawing that de Tocqueville made of a famous U.S. prison in Eastern State Penitentiary near Philadelphia, in which people were put in profound isolation, hooded if they left the cells. If you read the notes from de Tocqueville and Beaumont, they're not identified by name, they're identified by number. And the idea was that 24/7 profound isolation would bring you to repentance and to changing your ways. So why do we need in 2024 to know anything about this? Well known, tolerated, and parallels today. Moreover, here in the era of Tocqueville, with the rights of man, here I am in Paris talking about this, Tocqueville and Beaumont's monograph describes the behavior and the control as despotic. And they don't use the word despotism negatively. They explain that it's an imposition of discipline that they observed in their 1833 monograph. Citizens subject to the law are protected by it. They only cease to be free when they become wicked. So a good deal of contemporary political theory pays appropriate respect to Beccaria, Bentham, Lucas, Beaumont, Tocqueville, but much less to what they helped create, which was then a new social science profession called corrections. On both sides of the Atlantic, prisons had been run by people who called themselves philanthropists or religious leaders or the like. But over the course of the 1800s, they came to scale themselves up and organize themselves as a discipline. First, meetings were held here in Europe in 1847 and 57. Then, of course, the upsets of here on both sides of the Atlantic. So after the Civil War, the city of Ohio the city of Cincinnati in Ohio hosted the first National Corrections Congress. Here's a plaque put up 100 years later, commemorating their declaration of principles about the treatment of prisoners, which is, as they mark on this plaque, the basic guide for modern correction systems. These folks rejected formally the redemptive suffering that their predecessors had embraced. In theory, it wasn't supposed to be menial labor and terrible food. Instead, they conceptualized crime as a pathology to be cured through indefinite confinement. They sought classification, individualization, useful work, daily discipline, religious instruction. Rehabilitation was the aim, and the power to deem someone rehabilitated resided with the prison men, the people who ran prisons. So this 1870 organization came into being, called the National Prison Association. It's now the American Correctional Association, and it in turn spawned in 1872 a meeting in London, which created something called the International Penal Penitentiary Commission that lasted till 1951. voluminous issues, mostly in French, of their 5-year annual congresses, their many meetings in between, debating what they describe as the best practices for prison management. So here they were being corrections, no longer philanthropy, no longer sociology, no longer penology, no longer criminology. They were corrections, and corrections meant control. And the people they sought to control, they devised as they were thinking of themselves as humanitarian, horrific forms of degradation. And I'll give you just one picture from London. This is a 1902 English prison of something called a treadwheel, where men are made to walk in endless 7-step rotations, horrifically for hours on end. And the claim is that it was for the safety of the community and the reformation of the individuals that these various methods for controlling and degrading bodies were engaged. And so in the United States, there's a good deal of discussion, maybe here too, that the US is exceptional. What I'm showing you is a transatlantic creation of the conception of prison as we have come to understand and know it, with an odd mixture of people who were in fact making it less awful than the rot and the clutter they saw, and yet in many ways were making it equally awful in other directions. And because they were transnational and colonial, their unself-conscious, racist, class-oppressive practices were transported around the world. And they generated what became normal and what became definitional of a thing called a prison. World War I interrupted their self-described march of progress. They were at the Eiffel Tower for one of their dinners in 1890. And in the wake of the war, a new critique emerged, and the visible, most vocal proponents are a group of wonderful feminists of whom I'm going to show you a picture. This is Marjorie Fry. And so finally, a woman enters this story as a major speaker. She was head of the all-female college at Oxford when this portrait was painted. And it's one way to pay tribute to this brilliant feminist political theorist and activist who should be hardwired to punishment discussions, but are not actually in most of the courses I know about. In 1926, these women called on what they called the world's conscience to recognize the torture, their word, of prison, and they argued the need for an international convention on the rights of all detainees, not just prisoners. Rights is their word. They documented physical abuse in Europe, and they pushed their agenda on this International Penal Penitentiary Commission and on the League of Nations, which had just been founded in 1920. And these remarkable women overcame many odds, and they won. Part of it was they did this pop-up in Geneva in 1927 to lobby the League of Nations, and they persuaded the League, working with the International Penal Penitentiary Commission, to create the first ever standard minimum rules for the treatment of prisoners. But those rules did not include their words of torture nor their words of right. But they did come into being, and here they are. And again, some French and some English. So these 55 propositions were guidelines. Don't be confused about the word regla or rules, because they were humanitarian invocations, which were aiming to both improve the conditions of people in detention and get funding for the people who run prisons to do so, and therefore to generate a new set of baselines around the globe. When you read their rules, you realize how awful the world was. Rule 8, for example, calls for food sufficient in quantity and quality, which tells you there wasn't, and something about water, light, and air. When you come to punishment, you see what these rules provide. In certain countries, this is a nod to England and its colonies, corporal punishment in dark rooms could be used as long as determined by law and licensed by a medical officer. My footnote is, if you ever see a punishment in which you need a doctor's permission to do it, it should be clear enough you should never do it. But here we are with this instantiation. And many countries didn't want whipping, France among them, but the Anglo-Saxon influence prevailed. So you see this rule that licenses the whipping I showed you in both Amsterdam and in Connecticut under prison authorities' decision-making. And moreover, dark cells, dungeons, are licensed as well. The idea was that this would become guidelines from around the world, and here in 1938, Her Majesty's Stationery Office prints a copy with the whole regalia on the front, its frontispiece. Pause for the dates. 1933, Hitler takes Germany. The League of Nations promulgates its rules in 1934, and these rules get circulated. Another date of relevance is 1935, where this Penal Penitentiary Commission made the tragic decision to meet as it had planned in 1930, but nonetheless kept it in 1935. They met in Berlin, where they were welcomed by the Nazis in the name of Adolf Hitler. The chair was Edmund Bunke, who was then the Chief Justice of the Reich's Supreme Court, and after the Allies took Leipzig in 1945, he killed himself. Throughout the war, Second World War, this organization worked with funding from Italy, Japan, Germany, and others, and wanted to keep going under the view that it was a professional organization, that corrections was apolitical and scientific, the realm for experts, not for politics. And hence it didn't matter what the country's politics were, because all you were doing was managing people in prison. That conception was wildly out of sync with the 1949 founding with the United Nations, the creation of the Universal Declaration of Human Rights, and hence this organization died, but its template, every 5-year Congress's standard minimum rules, has continued to this day, albeit with some changes. So before its closing, this is the frontispiece of its last volume at The Hague, where it met, and you can see the world as it understood it, which is white, male, European men, largely with a couple women and a couple people from Asia. So the intervention of the United Nations upended this vision in varieties of ways, including that the participants became much more diverse, and the name of the organization's meetings in this century changed to crime prevention, not standard minimum rules for the treatment of offenders, crime prevention and criminal justice reform. Before I talk a little bit about the content, we need to talk more about the context and the baseline. The baseline in the 1950s in Europe were concentration camps, and the baseline in the United States was enslavement and the moves for racial equality and the civil rights movements to move away from plantations and racial hierarchies and subordination. And within those baselines, prison had a new challenge because slavery and concentration camps look a lot like incarceration, and the question became whether incarceration would face its history and distinguish itself or not. And the reason I make this point with this picture on the screen is one of the men there had run the Belgian prison system and was briefly interred by the Nazis. And he's the only person I found in 100 years of reading all these congresses who'd ever himself been imprisoned. And more than that, he said, the radical invasion of human autonomy will, upon time, come to be seen as bizarre and illicit and illegitimate as the corporal punishment we are now abandoning. So we move forward from here to 1955 with the new UN, again still guidelines, a hodgepodge, 90+ rules now, leaving a good deal of correctional power intact, but with new predicates. And here's where the word right, which those feminists in the 20s had embraced, emerges in text. And you have a provision drawn from the Universal Declaration of Human Rights: no discrimination in prisons on the ground of race, color, sex, language, religion, politics, political opinion, national or social origin, property, birth, or status. And moreover, under their guiding principles, we now see a rejection, we see a notion of recognizing imprisonment as afflictive. And then it goes on to talk about the right of self-determination, and the word liberty comes in. But the prison system shall not, except as incidental to justifiable segregation or the maintenance of discipline aggravate the suffering. Now, I call that phrase, which you'll see in other instances, a prison discount. And it's a discount because it says, don't do it unless you need to because of the existence of incarceration. And moreover, then when we get to the next, we're at the worlds of discipline. And here in the worlds of discipline, there's a change because corporal punishment and dark cells and all cruel, inhuman, or degrading punishments are now described as completely prohibited. But the corporality of something called close confinement, which is otherwise known as solitary confinement, and food deprivation may be as long as doctors say it's okay again. So to summarize this first segment, I've shown you that the practices of prison were forged and legitimated in transatlantic exchanges that generated a profession and normalized practices with an enormous amount of authority to the people who run prisons and with the radical limitations on autonomy. And I've just shown you the moments when prison becomes a problem for democratic orders. Because the question is, how will you understand, or can you understand, this institution as anything different than those in which all people were detained across Europe? And the sad commentary is that it took the enslavement and detention of all kinds of people to get the rebellion against this radical form of intrusion. And so now I want to spend the next segment telling you a little bit about the last 70 years and basically show you that in the last 70 years, the question has been, what will democracy do about prisons, and what's the relationship between the concept of something called rights and prisoners as rights-bearing equals and the concept of detention, and what's a line between permissible and impermissible punishments. So to be clear about my normative stance, as much as I appreciate the Enlightenment intervention for the need for justification for punishment, I agree, I believe we need to be completely disjunctive with their standard answers for the basis for the legitimacy of incarceration in terms of incapacitation and deterrence and retribution and the like, because the eras in which they wrote, prisoners were civilly dead on civil common law, no rights to property, marriage, contract, civil rights of any kind. And their question was, what can governments do to people? Once prisoners start inventing the concept of prisoners' rights, which they invent, they do not start from the proposition of what is the state to do to me, but what are the rights that I retain as a member of the state, as a citizen, as a participant. And it is that struggle to make meaning that where we are. So now I'm going to just talk a little bit about the United States for a minute. In the U.S. Constitution, it's the 8th Amendment that says, from 1791, Enlightenment era, that you can't impose excessive fines or have cruel and unusual punishments. And you see here the imprint of the Enlightenment, because the Supreme Court says punishment cannot be totally without penological justification. They got it. They got the idea of it. But that long list of Enlightenment justifications, which are not internally coherent, are incredibly capacious and could, in fact, license whipping, dungeons, and death. This sentence I pulled comes from a U.S. Supreme Court decision that says that it's okay to impose the death penalty because it is not without penological justification, because the belief of a state legislature that it could be a deterrent suffices for justification. And notice also that on the list of illicit purposes, not mentioned at all, are words like dignity and equality and protecting liberty as things punishment has to do, let alone the European rule names of normalization, regularization, and reintegration. In terms of rights, it has actually materialized such that in the US, where there is no general right to health care, prisoners have to have health care because otherwise deliberate indifference to known medical needs is cruel and unusual punishment, and you can't set out to impose excessive fines because you can't set out to ruin a person. So the words have had meaning that have limited And one of the reasons I want to show you this is I want to introduce you to some other people. In addition to not enough pictures of Marjorie Fry in the world, there are not enough images of the people who were incarcerated, who took these words to heart and claims of equality and transformed the shape of U.S. prisons. So the first person here is a man named Caleb Washington. He's depicted with some of his lawyers. He is, at the time of his incarceration in the 1960s, Alabama had a statute that said, white and colored convicts cannot be chained together or allowed to sleep together. And he challenged that as unconstitutional, and he won. Let me be clear, Alabama was unusual in having a statute, but it wasn't unusual in segregating its prisoners north, south, east, west, federal system with special racial discrimination against black Muslim prisoners at the time. When the case went to the U.S. Supreme Court, it was the first term when it was not all white, because Thurgood Marshall, who had argued the school desegregation case, was a member of the U.S. Supreme Court. And there was little question that the facial racial discrimination was going to topple, but the question was, could they discriminate nonetheless sometimes if they needed to? And here again is the same prison discount I showed you in the 1955 UN rules. Prison authorities have the right, acting in good faith and particularized circumstances, to take into account racial tensions in maintaining security, discipline, and good order in prisons and jails. See that as a form of a license with constraints that authorizes a great deal of power to prison officials, always acting in the name of security, discipline, and good order. And so this was a serious win, and it's also cabined. Caleb Washington was one of many amazing individuals who, subjected to horrific state power, challenged it, and I'm introducing you to another person. This is a real handwritten petition submitted, smuggled out of the prison, and filed in August of 1965 in a federal district court in Little Rock, Arkansas. A man named Winston Talley wrote this petition, or someone helped him write it, because he was being whipped by the state and by other staff and by other prisoner trustees, they were called. And he said his rights were being violated under the Eighth Amendment, cruel punishment, invoking the words that I showed you, and he asked that the whip, W-H-I-P-P, be stopped. Now, in many parts of the United States at the time, federal judges would have just dismissed him as not having any authority to bring the claim. But the Arkansas district judge who got his claim admitted it, appointed very important state lawyers to represent him, and other prisoners who sought to stop the whip. And here's a slide of a newspaper story describing these white men who were challenging the whip and their witnesses having their say in court. So this is one way for me to underscore, and contra Foucault, that prison was not hidden. These whippings were not hidden any more than they were in Amsterdam or in Connecticut. They were known and they were tolerated as a form of discipline the state insisted was important, because they wanted to punish misbehavior, and including the failure to pick the requisite amount of okra or cotton to make the daily quotas. At the time of this case, Arkansas had no budget line for its prisons. It was all sweat labor from the people who were incarcerated and pushed to do so. Now, Talley won by getting into court and getting a lawyer, but the judge said you could whip if not arbitrary, regulated, not more than 10, and you had rules to follow. The following year, more prisoners brought another case. Judges again appointed lawyers. There's a transcript of a 640-page trial transcript, I believe, of the only whipping trial that was ever held in the United States. And then in the intermediate appellate courts, after here's this whip picture that you see, the public whipping is visible, not disputed, defended as needed. Finally, the intermediate appellate court says, we will ban the whip. It is cruel and unusual punishment. In a long opinion in which he argues, the court decides, it offends contemporary concepts of decency, human dignity, the precepts of civilization we profess to believe in. And he then goes on to say, if whipping were to be authorized, how does one or any court ascertain the point that would distinguish the permissible form from that which is cruel and unusual? That's our question. What's a permissible form of punishment as contrasted with one that is impermissible? Now, when they're writing this, they understand, these judges, from their private correspondence, that solitary confinement is a corporal form of punishment. They are nervous about intruding too much on prison authorities' discipline. This is the first case in the history of the United States that rules out a form of discipline a prison system wants categorically. And within 2 years, the same group of judges that had initially said, well, maybe you can whip, we have to defer to you, finds the whole prison system cruel and unusual and unconstitutional as a dark and evil world full of horrific violence, deaths, filth, and then there's 14 years of trying to implement this and trips to the US Supreme Court. What I want to underscore is I'm no way telling you a story about either a specific state, Arkansas, Alabama. I can tell you about Ohio, I can tell you about upstate New York, and here's where I'll show you a picture of Attica. So in 1971, there's an uprising in Attica prison. And hence the prisoners I'm describing are a mixture, some who are individuals and are not affiliated with political organizations and themselves are limitedly educated, and others of whom understand themselves as part of a social political movement around equality, non-subordination, and rights-bearing. Some of them are part of the Nation of Islam. And together they work a remarkable change in the landscape. And during the 1970s, in addition to US Supreme Court decisions, there's litigation, legislation, American Bar Association, American Medical Association, judges in Rhode Island, New Hampshire, Louisiana, across the country are writing opinions rejecting the degradation of incarceration, insisting that nobody be warehoused, deteriorate, or debilitated. And that looks promising until, and this intersects with the morning lectures, the war on crime, the war on drugs, the ramping up of a sense of insecurity, material and not, increases. And so now we're going to Ohio, and this is a newspaper picture of a cell that's smaller than a then current automobile. It's lined up against the automobile you can see. And people, we heard the Netherlands has 103% capacity. Try 200% capacity, where people are being put, 2 people or more, in a cell built for 1. And I know there are cases here about France as well. So prisoners challenged this, and they won in the lower courts, but in the US Supreme Court, and they not only won in the lower courts, but I need to underscore, they weren't doing anything but being conventional in the sense of standards. From the 1870s to then, every institution of authority, medical, legal, the federal government, everybody said 1 person, 1 cell. Bad for disease, think COVID, bad for violence, bad for staff, bad for everything, do not double cell. And in the US, by the way, unlike some prisons I've been in Europe, there's no protective area, the toilet is open. So there's no privacy of any kind and great anxiety. Unfortunately, in 1981, the US Supreme Court licensed double celling and therefore licensed the turbocharging of all of our institutions. And if you want to see the impact, here's a California prison in 2011. These are pictures that were in, or 2010. These are pictures that are in a US Supreme Court record. That metal box at the bottom is where people who were described as mentally ill are waiting for something they would call treatment. And there's so much congestion in the dormitory style that the records show that the staff didn't even know somebody had died because there was just no way to provide safety or health care in this kind of radical density. And so this is a decision 5-4 where the Supreme Court agrees. You can de-densify a little bit. The intersection, potentially counterintuitive, the licensing of radical density is hand in glove with the licensing of radical isolation called solitary confinement. 24/7 in a cell, in the US setting sometimes for years or decades. And in 1995, the US Supreme Court, in a terrible decision, described profound isolation for 30 days as not a dramatic departure. There was no liberty interest because it wasn't atypical or a significant hardship in relationship to the ordinary incidents of prison life, which is to underscore for you again and again, what's your baseline? If the US Supreme Court imagines ordinary prison isolation, what's the big deal? About a decade later, the court said, well, if it's 24/7, lights on all the time, indefinite forever, will at least give you a little hearing or some due process before you end. So here, I'm thick into debates about solitary confinement and isolation. And of course, one question is, how do you define it? And I've told you that these are all totally cheerful definitions of 24 hours or less as compared to the decades or years. And I'm part of helping to document. First of all, there's been a shift, and this is more about reimagining punishment. 15, 20 years ago, people who were in prison said, we got to do it. Solitary confinement's the way. Over political, social activism, with intellectual entrepreneurs, with social activism, with the families and the people who were in detention, who went on hunger strikes and made themselves incredibly visible, and with Guantanamo's detention, there's been a pushback, and so you're starting to see legislation in many states saying, not if you're pregnant, not if you're under a certain age, not if for anybody for certain times, or some limits and at least some reporting and the like. And for those of you who are interested, there's a website that the organization at Yale that I'm involved in called the Lyman Center, called Seeing Solitary, that can give you much more of the data. And so this transnational, and I want to come back full circle, because I started by saying US and Europe are not disconnected in this conversation. As many of you know, the Nelson Mandela Rules of 2015, the UN's newest version of the standard minimum rules for the treatment of prisoners, says that 15 days or more in solitary confinement is cruel, unusual, degrading treatment that could amount to torture. So the interaction between the national and the supranational or the transnational remains incredibly important in both directions, informing, and of course I can't be here without invoking the European prison rules, which have these ideas of regularization, normalization, and reintegration. I want to add that that in addition to the remarkable role that the incarcerated people and their families and networks have played in insisting on their individual rights and liberty, another pressure on prison reform, which we heard again this morning about, was the understaffing or the overpopulating of prisons interacting with the fact that it's hard to get staff. It's terrible to work in prisons. It's terrible because at least in the US system, you have extreme autonomy restraints. You can't keep your cell phone. You can't, there's a lot of rule-bound behavior. And there's a great deal of documentation that staff who work in prisons are ill. High blood pressure, anxiety, higher rates of violence in their household, suicide, earlier deaths. So we just held a program called the Toxicity of Detention at Yale to explore with the medical profession and other allied professions how to think through lessening the toxicity of detention. And so the vacancy rates are enormous. The scale is enormous. On the world of privatization, the corporate transnational corporations promise to provide care, and some of them promise to provide rights. And so in this punitive moment, the capacity to deliver on those claims will either cause the institutions to topple and retreat, or, worrisomely, Tocqueville and Beaumont's horror at the melange of French prisons as a noisy, mixed up, unclassified, bad place for which they ended up admiring the isolation in the United States may return to us. So let me conclude with a few summary takeaways in my parlance. First of all, punishment practices are not static. They change, and every era has their abolitionists. And the question is, abolish what? But we don't actually in the United States and in many places whip anymore, and we don't have chains, and we don't starve as well. Second, the people under the state's control have had a huge impact in terms of insisting and winning on some form of rights claims and deserve their place in the pantheon along with the fancy Enlightenment theorists. Third, a new and different kind of constraint on the legitimacy that delegitimates government punishment has to come into play, which is my last slide here. I just remind you that the licit purposes under an Enlightenment were incapacitation, retribution, deterrence, rehabilitation, consistent with safety and cost, French and English. And I want to argue for what I would call an anti-ruination principle, that in order to be true to commitments to rights bearing, the anti-ruination presumption has to be that the state can't, in a social order that sees itself as democratic, set out to take down, disable any member of its body politic. It may be able to punish you, but not by putting you in disabling, debilitating settings, which is not the same as rehabilitation, which has hierarchical connotations. It's not about civilization. It's not about corrections. It's about recognizing the personhood. And here, coming back to another of the morning lectures, doing so is incredibly expensive. And in addition to being expensive, and coming back to Jeremy Bentham, for whom I have a great deal of respect, he has a phrase about how some people will begrudge prisoners any help, and others will decry as a lack of humanity the degradation. And that captures the emotion we live in, where it really upsets people to give prisoners something that they are not getting. Now, Europe, that giving is cushioned by some social welfare. In the United States, prisoners get health care which non-prisoners don't get. And this goes back to your point about tied fate. The only way that prison can be rescued from its concentration camp, enslavement, plantation history is if we understand the tied fate, and people on the inside and outside, in addition to openness of the facilities, have equal resources from the state, except that if you take away liberty, prisoners are eligible plus in having to get more because they don't have any way to get their own. And so the US is exceptional today by being exceptionally awful on social welfare. It's not characterologically necessarily meaner. And by the way, all of us are racist colonial societies that have had hierarchies of enslavement of various kinds. It's that in the United States, we lack minimal safety nets. And the question about how to materialize an understanding in the popular imagination that we're all in this together, and our safety and security isn't just about taking them away and making me safe. It's about how can we all be safer, is an imperative for governments. And I think one way to help marshal this is to try to make clearer, while prison isn't invisible, the degree of bizarre control over human motion and movement, of which solitary is the epitome but not exclusive, needs to become clearer. That you can't, I couldn't move like this, or I couldn't get that piece of fruit, or I couldn't do things that are so normal. And so my hope is that you have heard that there was nothing prefixed about the existence of incarceration in its practices that evolved. It was made by a series of people debating the permissible in punishment. If it's going to be unmade, it's because of events like this that invite large public discussion to say that collectively we are the source of punishment, we are the line drawers about the permissible and the impermissible, and we will be the sources of change or not. Thank you.